Hello everyone, welcome back to Labor Standards and Social Legislations. In our previous video, we discussed about the basic terms that are used in labor standards and social legislation, like labor laws, social legislation, and labor relations. We also have discussed to you the how we interpret and implement the labor code of the Philippines and its IRR, including labor contracts. We said in our previous video that any doubts as to the interpretation and implementation of labor laws and labor contracts shall be resolved in favor of labor. However, it doesn't mean that this particular article, Article 4 of the Labor Code, is anti-employer. In many cases, the Supreme Court has recognized the rights of the employer to exercise its management prerogatives. Now for this video, we will talk about management prerogatives. Management prerogatives refer to the freedom and prerogative according to their discretion and best judgment to regulate and control all aspects of employment in their business organizations. Such aspects of employment include hiring, work assignments, working methods, time, place, and manner of work, tools to be used, processes to be followed, supervision of workers, working regulations, transfer of employees, work supervision, layoff of workers, and the discipline, dismissal, and recall of workers. This means that in hiring employees, the employer sets the minimum qualifications. If you can notice, or if you have already tried applying for a job, diba, you can notice that the job postings states or provides for the qualifications for employment, like you should be a graduate of a particular degree, or you should have a working experience. Because these are management prerogatives. The employer has the right to set standards, to set qualifications for persons they are going to hire. And in the exercise of this right, the court does not usually interfere. Hindi nakikialam ang korte or ang batas tungkol dito. Kapag ang employer ay naghanap ng empleyado, meron siyang karapatan na iset kung ano yung mga qualifications at kung sino ang kanyang dapat i-hire. So hindi pwedeng makialam ang korte tungkol dito. So ito ang ibig sabihin ng management prerogative. Work assignments. So the employer has the right to assign to you work or job. So what should you do inside the work premise? Working methods. Kung ano yung method na dapat mong gamitin. Time, place, and manner of work. So the employer decides these things. And you cannot say no to the employer. For example, you are required to report for work from 8 a.m. to 5 p.m. And you cannot say no to your employer because the employer sets the rules and regulations of employment. Tools to be used, processes to be followed, supervision of workers, working regulations, transfer of employees. So if there is a valid reason for the transfer, it is not meant to punish the employee, then that transfer of employee is a valid exercise of management prerogative, including the discipline of employees. If the employee committed a violation of the rules, then the employer has the power to discipline him or even dismiss him from work. Or the employer can also recall workers if the employer decides or intends to. So take note of these aspects of employment that are covered by management prerogatives, which the employee cannot question unless, of course, it violates the rights of the employee. Okay, so let's discuss Placido Urbanis versus CA, GR number 138379, decided on November 25, 2004. So here in this case, the Supreme Court held that our laws recognize and respect the exercise by management of certain rights and prerogatives. For this reason, courts often decline to interfere in legitimate business decisions of employers. In fact, labor laws discourage interference in employers' judgment concerning the conduct of their business. Even as the law is solicitous of the welfare of employees, it must also protect the right of an employer to exercise what are clearly management prerogatives. The free will of management to conduct its own business affairs to achieve its purpose cannot be denied. In the case of Duncan Association of Detailman PTGWO and Pedro A. Texon versus Glaxo Wellcome Philippines Incorporated, GR number 16294, decided on September 17, 2004, the Supreme Court upheld the policy of the employer which prohibits its employee from marrying an employee of a competitor pharmaceutical company to guard its trade secrets, manufacturing formulas, marketing strategies, and other confidential programs and information from competitors, especially so that it and Astra are rival companies in the highly competitive pharmaceutical industry. So, in order to protect the trade secret of a company, the prohibition on marrying an employee of the competitor company was held to be valid as decided by the Supreme Court in this case. Because, according to the Supreme Court, that is part of management prerogative. Because generally, in our labor law, it is prohibited for the employer to prohibit its employees to marry an employee of or to marry another employee. So if you can relate this, there are companies that prohibits its employees to marry each other. I don't know if you are familiar with this rule. There is a provision under the labor code that prohibits this kind of arrangement or this kind of rule or regulation in the employment. And so any prohibition in the contract of employment between an employer and employee which provides that the employee cannot marry another employee within the company premises is considered void by the law because it is contrary to law. But here, in this case of Duncan versus Glaxo Wellcome Philippines, the Supreme Court upheld the prohibition because what is prohibited here is that the employee of Glaxo is prohibited to marry the employee of a competitor company. So the Supreme Court said that this is an exception to the general rule because here the prohibition is in order to protect the trade secrets, manufacturing formulas, marketing strategies, and other confidential programs and information of Glaxo Wellcome Philippines. And because of this valid reason, the Supreme Court said that to marry an employee of a competitor company would be to affect the interest of the employer in protecting its trade secrets. And therefore, that prohibition is valid as an exception to the rule that the employer cannot prohibit its employee to marry another employee, or prohibition on marriage, or any provisions that prohibit marriage. Okay, so we said earlier that the employer has management prerogatives, which the courts cannot interfere if these management prerogatives are exercised within the bounds of the authority of the management or the employer. But that is only a general rule because the exercise of management prerogatives are subject to or is subject to limitations. And what are the limitations? Number one, It is limited by law. Under the 1987 Constitution on the requirement of due process, it means that if you will dismiss an employee, you should comply with the due process requirement. That you cannot just dismiss an employee automatically without giving the employee the right to be heard or without giving the employee the opportunity to explain his side. We also have a provision in labor relations law wherein employers are mandated to respect the right of workers to self-organization under pain of criminal prosecution. So just remember this particular principle because you will learn this later in labor relations law. The exercise of management prerogative is also subject to the collective bargaining agreement. Example, union security clause. So what is this union security clause? It means that you cannot terminate the employment of an employee based on union activities. So that is union security clause. So there are management prerogatives that are being compromised under the collective bargaining agreement. So if there are provisions in the collective bargaining agreement that limits the exercise of management prerogative, then the employer is mandated or required to abide or to comply with the provisions of the collective bargaining agreement. Employment contract, example of this is the probationary contract. Although in a probationary contract, the employment term of the employee or the probationary employee is limited only to a period of 6 months. But in that probationary contract, the employer cannot terminate the employment of the probationary employee within the 6 month period. So there is this security of tenure no, in probationary contract. And therefore, the employer must respect the security of tenure of a probationary employee within the probationary term of 6 months. Employer policy. So when you say employer policy, these are self-imposed limitations by the employer. So in every organization, the management ordinarily imposes policies and regulations. And in the exercise of management prerogative, the management should abide with these policies, which are imposed by the employer himself to the employees and to the conduct of persons inside the employment premises. The exercise of employment or the management prerogative is also subject to company past practices. So these are practices which are once they have been practiced for a long period of time and have ripened into a benefit, they cannot be withdrawn by the employer. Example of this is the giving of yearly bonus. So even if the giving of yearly bonus is not stated in the employer policy or in the employment contract or in the collective bargaining agreement, if the employer is giving a yearly bonus and this has been practiced by the employer for a long period of time and have ripened into a benefit, the employer cannot automatically withdraw this benefit anytime because this has become a company practice. And a company practice becomes a vested right to the employee if it has been practiced for a long period of time, even if this is not included in the CBA or in the employment contract or in the employer policy. General principles of fair play and justice. So if there are no provisions under the law or if there are no stipulations in the collective bargaining agreement, contract, or in the policy, or there are no company practices, then the general principles of fair play and justice will come into play. So kapag walang batas, walang contract, walang practice, then the soundest exercise of right reason given a circumstance will apply, or the general principles of fair play and justice will apply. So let us discuss one by one the specific management prerogative and its limitation. Let's start with the right to hire. So we mentioned earlier that this is one aspect of employment that is covered by management prerogative. We said that the employer has the right to set minimum qualifications for hiring, that it can select, it has the right or the power to select who to hire, what requirements or qualifications to be imposed for hiring. But take note that this power or this authority to hire has limitations, and the limitations are found under certain provisions of the law. So let's start with hiring of minors. So the hiring of minors is governed by Republic Act number 7610, or the Anti-Child Abuse Law. We also have Republic Act number 7658, an act prohibiting the employment of children below 15 years of age in public and private undertakings. Republic Act number 9231, an act providing for the elimination of the worst forms of child labor and affording stronger protection for the working child. And RA number 10361, an act instituting policies for the protection and welfare of domestic workers. So we also have Article 134 of the Labor Code, stipulations against marriage. This is what we discussed earlier about the Duncan case, that generally stipulations against marriage are prohibited. So bawal yan sa batas. Bawal na i-prohibit mo yung employee mo na mag-marry. Sabihin mo na, you should be single, otherwise I will dismiss you. That is prohibited under the law. But by way of exception to the rule is the Duncan case. If the employer protects, or the intention of the employer is to protect its trade secrets, its secret formulas, then any stipulation against marriage for that reason will be valid. So another limitation is under Republic Act number 10151, an act allowing the employment of night workers. Which provides for night work prohibition, for women night workers if during pregnancy and after childbirth. So there are specific provisions here that prohibits night work, for women workers. We also have Republic Act number 7277, an act providing for rehabilitation, self-development, and self-reliance of disabled persons. So this particular law provides for anti-discrimination provision on employment of disabled persons. So meaning to say, the employer should not discriminate any disabled person's applicant for employment, okay? And also for self-development like promotion, increase in payment, etc. We also have prohibition on yellow dog contract. What is this yellow dog contract? This is an agreement which exacts from workers as a condition of employment that they shall not join or belong to a labor organization or attempt to organize one during their period of employment, or that they shall withdraw therefrom in case they are already members of a labor organization. So This means that you are, or the employer is prohibiting an employee to join unions. So that is prohibited. So the employer cannot impose that yellow dog contract. RA number 9208, Anti-Trafficking in Persons Act of 2003. So it shall be unlawful for any person, natural or juridical, to commit any of the acts of recruitment, transportation, transfer, harbor, provide, or receive any person by any means, including those done under the pretext of domestic or overseas employment or training or apprenticeship for the purpose of prostitution, pornography, sexual exploitation, forced labor, slavery, involuntary servitude, or debt bondage. So anything that is illegal. So you cannot hire persons in order to traffic them. We also have provisions for Anti-Sexual Harassment Act of 1995 or Republic Act number 7877. So bawal yan. The sexual favor is made as a condition in the hiring or in the employment. So which means that if the employer will provide for a condition for employment, like you will be my girlfriend so that I will hire you. So that is prohibited under the law. While it is true that the employer has the right to hire persons, has the right to set the minimum qualifications for employment, but they are not allowed to make as a condition of employment the grant of sexual favor. Also, under Republic Act number 10911, prohibition of discrimination in employment on account of age. So the employer cannot decline any employment application because of the individual's age. Like for example, if the person is already 50 years old, so you cannot deny or decline employment merely by reason of his age. So let's proceed to the management prerogative to promote. So what is promotion? Promotion is one of the vital management prerogative. It is defined as the advancement from one position to another involving increase in duties and responsibilities as authorized by law, and increase in compensation and benefits. But take note that promotion does not mean salary increase. Any increase in salary should only be considered incidental but never determinative of whether or not a promotion is bestowed upon an employee. So it doesn't mean that if your salary is increased, you are already promoted. And it also doesn't mean that if you are promoted, there would be a salary increase. The employee has all the right to refuse promotion. So the employee may not accept, has the discretion to accept promotion. Because there is no law which compels an employee to accept a promotion. Promotion is in the nature of a gift or a reward. Any person may refuse to accept a gift or reward. Such refusal to be promoted is a valid exercise of such right, and he cannot be punished therefore. Let's go to management prerogative to demote. Demotion is defined as a reduction in position, rank, or salary as a result of a transfer. So in the case of Philippine Wireless Incorporated versus NLRC, GR number 112963, July 20, 1999, the Supreme Court held, there is demotion when an employee occupying a highly technical position requiring the use of an employee's mental faculty is transferred to another position where she performed mere mechanical work, virtually a transfer from a position of dignity to a servile or menial job. So when you say demotion, it means that there is a reduction in position, rank, or salary. It also means that even if your position is not reduced, or your rank is not reduced, or your salary is not reduced, if there is a transfer from a position of dignity to a servile or menial job, meaning to say your previous position is highly technical in nature, like it requires expertise or your professional expertise. And now you are transferred to a rank and file job or a job which is ministerial in nature, like it does not require your expertise. So if that is the case, even if there is no reduction in the position, hindi bumaba yung position mo, yung rank mo, hindi din na-reduce yung salary mo, but still, the Supreme Court said that that particular transfer is considered a demotion because previously, you are occupying a position which requires the use of your expertise. And now you are transferred to another position which is ministerial. Yung it doesn't require na your technical expertise and therefore it is considered as a demotion kasi merong transfer from a position of dignity to a servile or menial job. The employer has the right to demote and transfer an employee who has failed to observe proper diligence in his work and incurred habitual tardiness and absences and indolence in his assigned work. So if there is a valid reason for the demotion, then that demotion is valid. It is a valid exercise of management prerogative. However, in the exercise of such prerogative, the essential element of due process is required. So meaning to say, you cannot just automatically demote a person. You should give that person or that employee a reasonable opportunity to explain his side in order to give him due process or due course before you demote that employee. So if there are valid reason or if it is justified that the employee has committed certain violations of the company's policy, then you can now validly demote or transfer the employee. Now let's proceed to management prerogative to transfer an employee. So in order for the transfer to be valid, the following requisites must be complied with. Number one is there must be no demotion or diminution of benefit. Meaning to say, if you are occupying a position with the salary of 10,000 pesos and you are now transferred, the transfer must not result to a reduction in your salary. Second is the transfer is not unreasonable, inconvenient, and prejudicial to the employee. So say for example, you want to transfer the employee to another branch and the transfer must not be unreasonable or inconvenient. Say for example, if you have another employee who can be who is willing to be transferred to that new branch, then you might choose him. Pwede mo siyang piliin na siya yung i-transfer mo instead of transferring another who is not willing to be transferred. Otherwise, that transfer would be unreasonable, inconvenient, and prejudicial to the employee. Another example is if you have an employee who is a resident of the place where the new branch will be located, then it is reasonable to transfer him to that new branch because he is a resident of the place where the new branch is located. So if you will transfer an employee who is not a resident of that place, then it could be unreasonable or inconvenient for the employee. But if there is no employee available or willing to be transferred in that place, or there is no employee that is a resident of that place, then the transfer could be a valid transfer, could be reasonable. Kapag wala na talagang ibang employee na pwedeng i-transfer and there is a need to transfer an employee there in the new branch, so pwede siyang maging valid transfer kasi wala nang ibang pwedeng i-transfer. But kung merong ibang pwedeng i-transfer to that new branch and yet you still transfer that person or that employee na hindi naman, wala namang reason or it would be prejudicial to him, then the transfer is not valid. Third, it is not facade to get rid of the employee as a form of punishment. So when you say it is not facade to get rid of the employee, it means that the transfer must not be to punish the employee. Say for example, the employee had committed a violation or had insulted the manager, and now in order to retaliate or to punish him, you transferred him to another branch. So if that is the case, the transfer is not valid. Subject to Article 100 of the Labor Code, which means that such transfer should be done without diminution of rank and benefits. So this is the first requisite. In cases of transfer of employees, the employer has the burden of proof to refute the allegation of illegal or constructive dismissal by the employee. So what is illegal or constructive dismissal? It means that if the transfer does not comply with the requisites of a valid transfer, then the transfer constitute an illegal or constructive dismissal. And the employee, as a result, may file a case for illegal or constructive dismissal against the employer. And in that particular case, the employer has the burden of proving that that transfer is not an illegal or constructive dismissal. So therefore, before the employer can exercise its management prerogative to transfer an employee, make sure that that transfer will comply with the requisites of a valid transfer. Otherwise, the transfer may be considered an illegal or constructive dismissal of the employee. Now let's proceed to management prerogative to discipline employees. The power to discipline refers to the employer's right to conduct affairs of his business according to its own discretion and judgment, includes the prerogative to instill discipline in its employees and to impose penalties, including dismissal upon erring employees. So the employer has the power to discipline its employees, but it is subject to a criteria, or it is subject to a criterion which provides that the policies, rules, and regulations on work-related activities of the employees must always be fair and reasonable, and the corresponding penalties when prescribed commensurate to the offense involved and to the degree of the infraction. So let me give you an example. For example, the employee committed mistake in his job, but the mistake is very light. It can be corrected by guidance, by mere guidance on the employee. Now, what if, for example, the employer disciplined the employee because of that simple mistake? The employer dismissed the employee. So, there is a violation of this criterion that the penalty that should be imposed to the employee must commensurate to the offense involved. Dapat it must be justified to the offense involved and to the degree of the infraction. Since the infraction is only light or simple, then the dismissal is not proper or it doesn't justify the dismissal of the employee. So pwedeng ano lang muna, reprimand lang muna. Pagsabihan mo muna yung empleyado that the commission of similar mistake will be meted with a severe penalty next time. So meaning to say, dapat yung penalty na impose mo sa violation is commensurate lang siya. Meaning, equivalent lang din siya. No? Hindi yung masyadong mabigat yung penalty sa offense na nakomit ng empleyado. So that is the guideline, no? the criterion in imposing the penalty of discipline or in exercising the power of discipline. The employer cannot be compelled to maintain in his employed undeserving if not undesirable employees. So kaya the employer has the right to discipline its employees or even dismiss its employees kapag the employee is undeserving or the employee committed several violations of the rules and regulations of the employer. So this is a recognized management prerogative. But again, subject to the criterion that The rules and regulations must be fair and reasonable, and that the corresponding penalties when prescribed commensurate to the offense involved and to the degree of the infraction. Management prerogative to manage the operation of the business. So this is an inherent right of the employer to do whatever it thinks is good for its business. This covers all acts of ownership but still subject to the general limitations. And lastly, management prerogative to dismiss. This is one of the powers of the management to discipline employees. No? It includes the power to dismiss. So employees can only be dismissed when there is just or authorized cause and there is observance of due process. So this power of the employer to dismiss employee is subject to the limitation that it must be based on just cause. There must be a valid reason for the dismissal, and that there must be an observance of due process, which means that the employer should give the employee a reasonable opportunity to explain his side, to be given time to give explanation before he can be dismissed from service. Okay, that ends our discussion for management prerogatives and its limitations. And for our next video, we will formally begin with Presidential Decree number 442 or the Labor Code of the Philippines. Goodbye and see you next video.